grateful to be in this great hall at a podium at which one of my favorite presidents stood, President Lincoln. But among such distinguished writers, if you must believe me, because I say it, right? I'm in awe. Thank you for letting me be a part of tonight. When I received the invitation to speak tonight, I reflected on the work that PEN does in support of freedom of expression, whether advocating for writers who are persecuted because of their work, or simply raising awareness of abuses of human rights, calling us all to account because ignoring such events makes us all less worthy of our own humility. And I asked myself, what can I possibly say today that won't be preaching to the choir? Jacob, director of the PEN World Voices Festival, thoughtfully suggested a list of questions about my work on the court that might be of particular interest to the PEN membership. Many are questions I prefer not to answer, and I hope my presentation today will explain why. The reason is bound up in my reflections on other questions he posed. Have I had any personal experiences with censorship or self-censorship? And then more broadly, how does the notion of freedom change depending on circumstances? Has my understanding of freedom changed since my appointment to the Supreme Court? I must preface my remarks today by saying that my own experiences of censorship since my appointment to the court is not a hardship. And it would be fastidious for me to compare it to the repression experienced by the writers that PEN supports or that some judges have endured. Judges have been threatened with public censorship or removal, economically persecuted to ensure their decisions conform to the will or public opinion, and even jailed. In some jurisdictions, judges are banished to a virtual Siberia to neutralize their voices. In many countries, judges are killed. We are fortunate that Article 3 of the US Constitution guarantees federal judges their positions for life, absent impeachment for a high crime or misdemeanor, and that no diminution of our salaries can occur during our tenure. These guarantees largely guard against much of the overt censorship that judges experience. Despite its rarity, the threat alone of impeachment or removal in response to a judge's decision causes untold anxiety and is often viewed as an assault on judicial independence. It is why so many lawyers and citizens in our country work assiduously to guard judicial independence against overt or even covert threats of censorship or impeachment for an unpopular decision. It's true. You can easily find instructions on the internet for how to impeach a judge, but accomplishing it is thankfully a very difficult matter. I do not claim any special bravery in my work on the court, but knowing that freedom is both fragile and precious, and its name too easily appropriated by those who would brand it exclusively with their own politics, or treat it as a commodity for export, or impose it by military force. We do well to study it closely, to learn how its facets show under different lights, how at one moment freedom may be indistinguishable from responsibility, and at another recognizes that it shares features of privacy. Let me give you some examples. Since its publication in January, the response to my memoir, My Beloved World, has been one of genuine surprise. Readers and critics have described it as, quote, amazingly candid, close quote, quote, revealing, and disarmingly personal, close quote. I can assure you that what I've written is not what is normally understood as confessional or tell-all. I know I'll disappoint some. If the writing seems unusually frank to most of my readers, I believe their response is because of the expectations that surround my role as a justice. The image of a Supreme Court justice is that of the most inscrutable of all public servants, enrobed in traditions of extraordinary professional privilege and privacy. Our lifetime appointments shielding us from the vicissitudes of political fortune as we confer behind doors that are closed even to our own clerks and administrative staff. Oral arguments offer just a sliver of visibility into our process as we work towards a decision. And that small opening becomes the occasion for dramatic prognostication in the press as pundits examine the entrails of every utterance for some hint of how we will decide. A curious aspect of this sport is that our decisions and the logic that lead us to them will in due course be manifest, regardless of how the airtime or column inches have been filled meanwhile. A sportcaster's breathless account does not guide a ball through the air, and neither does the public commentary that follows oral arguments sway our decision. It is inadmissible, neither evidence nor argument by the parties in the case. The more interesting commentary, which I see so rarely in the press, would appear after we render our decision and would avoid the facile drama of rhetorical strategies or who might have been having a bad day at the podium. It would offer instead an analysis of our questions and what impact the responses had on the shape of our final opinions. A justice's decision may indeed hinge on a question that is probed in oral arguments, but the foundations are laid before that in our study of the briefs and of legal precedents. Nor do we reach our conclusions until we have a chance to consider what our colleagues have to say in conference. Our written opinions will integrate all of that process. The tendency instead to read newsworthy drama into every word of oral argument distorts the public's understanding of our work, and is what leads even those of us who value transparency over tradition to think carefully about welcoming cameras into the courtroom. Our opinions may indeed change after oral argument. They may change even in the process of writing. I'm sure the writers among you will recognize how wrestling a concept into a fixed form of expression can reveal unforeseen subtleties. It is not unknown for a majority opinion to be recast as a dissent. This course of deliberation is shielded from the public view for good reason. First, to avoid any premature outcry at the perceived direction of a justice's thinking that may intend to sway that thinking, but ultimately because of the fundamental belief that a fully reasoned decision is the best way of promoting people's faith in our process. The legitimacy of the court rests in the logical force of the opinions we write, how thoughtfully and persuasively we craft our words. As my colleague Justice Breyer has written, quote, "Justices do not simply announce a legal conclusion. They reason their way to that conclusion in an opinion written for all to see. The obligation to provide legally defensible reasoning in a publicly accessible format prevents a judge from escaping accountability. Indeed, a good judicial opinion is transparent and informative. It shows that the decision is principled and reasoned. The strength of this reasoning matters," close quote. The secrecy and discretion that surround the court in its deliberations are thus carefully considered. They are not only weighed in the balance against the undeniable values of transparency in government, but they also nurture that transparency. The veil of privacy that shelters us from political influence and protects the public perception of the court is necessary because history shows that our authority is not unassailable. The Supreme Court is an instrument of democratic process that relies on the people's faith in our integrity, our impartiality, and our commitment to the Constitution. Maintaining the court's decorum and its respect in the public eye are not minor questions of image and public relations, but essential to the proper functioning of the institution and our democracy. In the same vein, when I give a speech or express myself publicly outside of court opinions, I voluntarily and scrupulously censor myself. I am cautious to avoid any topic that might foreseeably come before the court, or to express myself in any way that would telegraph a future decision, because it's clear that such expression can and does undermine the public's confidence in the court. Of course I have my opinions, beliefs, preferences, and emotions. I'm a thinking, feeling human being. But part of a justice's job description is to bracket those opinions and preferences and emotions so that they do not control our decisions. It's not that our silence proves the absence of prejudice. But if we don't even have the self-awareness and self-control to refrain from the appearance of impropriety, then how can we be trusted to set aside our personal leanings and focus on the question of law before us? So no, I'm not going to answer some of Jacob's questions today about the long-term implications of amnesty versus Clapper, or how Penn might hold the government accountable for torture and human rights violations, or what types of cases I might anticipate in light of the growth of digital media. I encourage you as citizens to think hard about such questions for yourselves. I encourage you as writers and intellectuals to bring those questions into the public discourse. I encourage you to engage with such questions actively in the democratic process. But I myself have been assigned to a different task in that process. I've been asked in my role as a justice to frame my answers on a neutral ground, without preconceiving judgments before the parties have a chance to decide for themselves what cases should be brought, and to build a record on those issues and present their arguments, before I myself have had a chance to deliberate with my other 8 colleagues, before each of us has thoroughly reviewed both the record before the court and all the laws and precedent the court relies upon. So, beyond the self-censorship that I exercise in public statements on legal topics, another important form of self-imposed censorship is that which calls on moral sensitivity and simple courtesy to keep baser instincts in check. You are aware, I am sure, that much hate speech is legally permissible if it does not meet the criteria of fighting words or the imminent danger of inciting lawless action. Citizens can be insensitive, rude, and even deliberately cruel in their speech without actually breaking the law. We've all had experiences with that. This cruelty covers the muddy ground of what has come to be known sometimes as politically incorrect speech, and the irony that has come to taint the term politically correct. Perhaps our times could benefit from a little less irony and a little more sincerity. I've written about a lesson learned from David Bakunin, a very dear friend and mentor who taught me much about legal ethics. and I quote myself, "In the practice of law, there are rules that establish a minimum standard of acceptable conduct, what the law permits. That is the floor, below which one can't go. There are other rules, not formally encoded, which set the higher bar, that define what's ethical behavior, consistent with respect for the dignity of others and fairness in one's dealing with them. Compassion," and now I go back to my talk, "compassion and humane considerations do not debase or undermine the law, but draw us to a higher personal standard than those enforced legally. In short, sensitivity in how I speak is just as important to me as what I say. The issues I am raising about the situational nature of freedom of expression, including the freedom not to express, the value at times of restraint or non-transparency, are closely related to concerns around a third issue, privacy. Today, the potential of new technologies and data mining to overset the bounds of privacy is a frequent topic of the public discourse, and it has come before the court. In United States versus Jones, where we considered whether extended GPS monitoring constituted an unwarranted search, I wrote in a concurring opinion, quote, "Awareness that the government may be watching chills associational and expressive freedoms, and the government's unrestrained power to assemble data that reveals private aspects of identity is susceptible to abuse. Who government, in its unfettered discretion, chooses to track, and for long periods of time, may alter the relationship between citizen and government in a way that is inimical to democratic society. I, for one, doubt that people would accept without complaint the warrantless disclosure to the government of a list of every website they had visited in the last week or month or year. But whatever the societal expectations, they cannot attain constitutionally protected status only if our Fourth Amendment jurisprudence ceases to treat secrecy as a prerequisite for privacy." The two things are different. The recent events in Boston will undoubtedly add to that discussion. But let me offer a simple example of the distinction between secrecy and privacy. I recently spoke at a very public event where Rita Moreno and I shared a stage and held a conversation in front of an audience of 800 people. To ensure Rita and I and the audience that we felt that we were in an intimate conversation, the press was not invited. It seems pointless today to exclude the press from any event when any member of the audience can tweet quotations. I'm sure some of you are now. The moment the words are uttered, or blog their reactions later in the same evening. But the exclusion of the press can often be solely an attempt to establish certain parameters of tone and context. So Rita and I planned to talk like girlfriends. We did. Playing a certain role for the benefit of the audience present in the hall to listen in. This may involve an element of theatrical illusion, but that is neither secrecy nor dissembling. Any social interaction, or as writers know, any verbal expression, is selective in what face it presents. This is simply a matter of sensitivity to tone, context, and style. The wealth of information that we share as social beings, the raised eyebrow, the small smile after a statement. And though Rita and I might laugh as if we were alone and talk of relationships and breakups and the allure of Marlon Brando, I am skilled enough to do it without impropriety or tipping my hand on any issue before the court. But the presence of press, especially televised press, can change the dynamic, raising the stakes and erasing the subtleties of tone. And might find myself censoring more heavily and dampening the mood, whether consciously or unconsciously. A couple of years back, I went to my high school to meet with its students. Afterwards, a number of them sent me a thank you letter, individually. And one of the young people said, "I didn't want to go to hear you speak. I thought you were just one of those other politicians who would prattle on and say meaningless things to me. But the minute I saw that you entered the room without trailing cameras, I realized that you might be a different kind of politician. And after hearing you speak, I'm glad I went, and I'm glad to know you're not a politician." I have learned in speaking publicly, as in my writing, to be cautious with words that are freighted with political baggage. I have learned from hard experience to avoid a provocative turn of phrase or a rhetorical flourish that might easily be lifted out of context and become a soundbite that refuses to fade away. All of you know what I'm talking about, right? Judges too must sometimes kill their darlings. Sometimes self-censorship is simply good craft and sensitivity to the purpose of one's words. If what I want the word to mean is not what others choose to understand by it, then I would do well to rephrase my argument rather than claiming, like Humpty Dumpty to Alice, to be master of the word. So given the traditional and very practical reticence of members of my court, given my concern for privacy as the spear of an individual's individual freedom, given the value I place on restraint, whether it's motivated by compassion or by common sense, why then did I choose to write a memoir that has broken all precedent for personal revelations from a Supreme Court justice? Why run the risk that others might mine the circumstances of my life story to extract hints on my legal thinking? Some critics have commented that I do, in fact, allude in my memoir to issues that may come before the court. It is impossible to live in this society and not in some way be affected by a court decision. It was impossible for a minority student like me to get a college education in the 1970s. I did without somehow feeling the impact, for better or for worse. I am a product of affirmative action. Just as it is impossible for a homosexual couple today not to be affected by the DOMA and Proposition 8 cases in some way. Memoirs, and no matter what we do. Just so you're all clear, I'm not predicting anything, okay? Memoirs will no doubt be written in the future that remember 2013 as a turning point for those whose lives will be changed for better or for worse by those rulings. When you live through a particular moment of this nation's history, you cannot be automatically disqualified from hearing a case that touches your life experience. Otherwise, there would never be enough judges to decide any cases. Which brings me back to my reason for writing an exceptionally candid memoir. Because at this moment in the arc of our nation's history, and where my own path as an individual happens to intersect with that, I am offering myself as a role model, and that can be the most valuable service I can perform, no less valuable than my jurisprudence. My goal in writing the story of my own journey from a childhood shadowed by juvenile diabetes, parental alcoholism, in a home where English was not spoken, where the horizons of opportunity were narrowly constrained, all I can do is offer hope. I wanted to inspire young people, minorities, those who have struggled with chronic illness, women, but anyone who has felt themselves marginalized by difficult circumstances, to know that someone like them can indeed stand in the public space and claim a voice in determining how this country imagines itself. I wanted to express my gratitude to the mentors who have helped me at each step of my own journey by using the pages of my book to mentor others on a larger scale. I knew I could not achieve such ambitious goals in a memoir without telling a good story, without my words capturing at least some corner of my readers' hearts. And that in turn could not be accomplished without some bearing of my own heart. The honesty and openness that the task required would make me vulnerable to personal criticisms, I knew. But it seemed a price worth paying. If my story was to serve a meaningful purpose, then people would have to identify with it. Vulnerability cuts both ways. If you want to reach and connect with other people, you need to open yourself to connection. In my book, I talk about how a functioning community and a humane social order depend on our being able to imagine ourselves in someone else's shoes. I wrote about the experience that helps me to understand that truth from a young age, about teachers who disparaged latchkey kids with working moms because they didn't imagine that a mother's desire to give her kids a Catholic school education might be her motivation to go to work. About the policeman who accepted shopping bags of free fruit as his due from the street vendor in our neighborhood, because that officer didn't imagine what a huge cut of a poor man's profit he was taking. I wrote about where I grew up, about the streets of the South Bronx that felt like a war zone, and that I was 15 years old when I understood how it is that things break down. People can't imagine someone else's point of view. At the same time, I was writing those words with the hope that a young person reading them today might conceivably imagine herself in the shoes of a Supreme Court justice. It cuts both ways. Many readers have labeled this understanding as empathy, or as a constructive and hopeful interpretation of what that word would mean. It's not a word that I use myself in the book. In the media storm that surrounded my confirmation hearing, that word was twisted to imply a favoring of emotion at the expense of the rational dictates of law. I'm not going to argue terms or play Humpty Dumpty, but I do know what it means, what makes a good story is the same thing that makes human connection and community, being able to imagine yourself in someone else's shoes. It's also one of the skills that makes you a good judge. You need to imagine yourself in the shoes of both parties that stand before you. You need to be sensitive to how your words are perceived on all sides, and you will value restraint and even self-censorship to ensure that your story achieves its intended purpose. These then are my reflections on Jacob's questions. Yes, I do practice self-censorship because it is often situational. And yes, my notion of freedom has changed since I became a justice of the Supreme Court. Being for the first time in a court of final resort, I have come to appreciate in an unanticipated way the great burden that my work imposes. When my court decides an issue, one party wins the case, but another loses. And many others will be constrained in their behavior by our decision. The freedom that I hold as a justice of this court is extraordinary. And I cannot for a moment lose sight of the fact that that freedom is defined both as choice and as responsibility. The responsibility to speak and act, pardon the pun, judiciously. And if I dare say it, wisely.